इनको बोलिए कौन खड़ी, इनको बैठ जाएं। हमारे यहाँ ये सब नहीं चलता, प्लीज ये सब मत करिए।
बैठा दीजिए।
पक्षकार को जितनी ये जो नेशनल स्कूल ऑफ ड्रामा की एक्टिंग है ना, यहाँ मत सिखाइए वो।
कन्विक्टेड अंडर सेक्शन 376(1) IPC 3(2)(v) ST/SC केस, आजीवन कारावास की इसमें हमको सजा हुई महिला।
सिमिलर टू 39 मान लो,
और
एज इज 16 ईयर 1 मंथ।
इसमें क्या 10वीं की मार्कशीट है क्या?
नहीं है, पर ऐसा लिखा है 10वीं मार्कशीट और 12वीं मार्कशीट में यही डेट ऑफ बर्थ हमारी एंट्री।
ऐसा लिखने से थोड़ा होता है, एग्जिबिट कराना पड़ेगा ना। एग्जिबिट नहीं है तो अब उसकी और माता पिता की ये जो स्कूल टीचर का सर्टिफिकेट देखना पड़ेगा।
जी सर।
तो सिमिलर से बेटर केस हो गया ये तो। सिमिलर से बेटर हो गया कि नहीं हो गया?
एग्जिबिट P17 दाखिल खारिज रजिस्टर, उसमें मैनिपुलेशन भी है साहब।
इनको बोलिए कौन खड़ी, इनको बैठ जाएं। हमारे यहाँ ये सब नहीं चलता, प्लीज ये सब मत करिए।
बैठा दीजिए।
पक्षकार को जितनी ये जो नेशनल स्कूल ऑफ ड्रामा की एक्टिंग है ना, यहाँ मत सिखाइए वो।
मेरा नहीं पता किनका।
किसने खड़ा किया था इस पक्षकार को? आपने?
नहीं, मैंने नहीं किया मामला।
हाँ तो फिर मना करिए, सब यहाँ एक्टिंग नहीं चलेगी। स्कूल टीचर मार्कशीट इज
Marksheet is not now there, not available.
नॉट अवेलेबल।
दाखिल खारिज रजिस्टर एग्जिबिट P17 is
P17
एग्जिबिट P17
इसने प्रमाणित किया है दाखिल खारिज।
PW4
घटना किस तारीख की है? 2003/7/23 की।
13/10/21
13/10/21
जी साहब।
FIR 2023 में है।
वो फॉल्स प्रॉमिस ऑफ मैरिज वाला
हैं?
फॉल्स।
अरे वो तो सब ठीक है। 3/7/23 FIR। अभी क्या शादी ब्याह हो गया?
1 साल हो गया सर शादी को।
साथ में रह रहे।
साथ में रह रहे हैं, साथ में नहीं रह
अरे रुक तो जाओ वकील। हैं?
1 साल हो गया सर महिला।
साथ में रह रहे हैं?
साथ में तो नहीं है कि माता पिता भी नहीं एक्सेप्ट नहीं कर रहे हैं और सास ससुर भी एक्सेप्ट नहीं कर रहे हैं, या ये रहना चाह रही है तो वो
रुक
honest
जाओ
है।
ना। Prosecutrix is the eldest child।
As per the PW2 मदर।
हाँ, सबसे बड़ी लड़की यही है ना।
जी साहब।
ये तो 2003 का जन्म बता रही है।
दाखिल खारिज में 2005 लिखा है।
अरे दाखिल खारिज में आप कुछ भी लिखे, माता पिता प्रूव करेंगे ना। मानस जी आप भी जो है ना
साहब, वो फिर बाद में आफ्टर FIR that is the something।
श्री शुभ नाम बताइए आपका।
संजय तिवारी।
संजय कुमार तिवारी फॉर द अपीलेंट। श्री मानस मणि वर्मा लर्नेड गवर्नमेंट एडवोकेट फॉर द स्टेट। श्री उपेंद्र सिंह लर्नेड काउंसिल फॉर द ऑब्जेक्टर। नेक्स्ट, with the consent of the parties, matter is heard finally. Next pair, IA 8077/25 is withdrawn. Next, learned counsel for the appellant submits that appellant is aggrieved of the judgment dated 12/3/2025 passed by learned special judge, POCSO Act 2012 Mandla in SC number 22/2023, whereby appellant has been convicted under section 376 within bracket 1 read with section 325 of SC/ST Prevention of Atrocities Act with life imprisonment and fine of rupees 2000 with default stipulation of 2 months additional RI. Next, it is submitted that it's a case of consent. Prosecutrix at the time of the incident was major. Full stop. The trial court has failed to appreciate that prosecutrix herself and her mother PW2 admitted that she was born on 5th April 2003. Full stop. Therefore, when incident is reported to have taken place on 13/10/2021, at that time prosecutrix was major. Yet, without appreciating these facts and overlooking the evidence of the school teacher PW4 Sri Yogendra Kumre, appellant has been convicted under the POCSO Act, which is arbitrary and unjust. Next one. It is submitted that this is the case for acquittal and therefore acquittal be recorded. Next pair. Shri Upendra Singh, learned counsel for the objector, does not oppose the prayer and submits that prosecutrix is married to the appellant. Her condition is precarious, full stop. She is neither being accepted by her in-laws nor by her parents, and therefore her life has become very difficult. Next paragraph. Sri Manas Mani Verma submits that in his school records, date of birth of the prosecutrix is mentioned as 12-10-2005 and therefore admittedly at the time of the incident which took place on 13-10-2021, she was minor, therefore no indulgence be shown. Next paragraph. After hearing learned counsel for the parties and going through the record, comma, it is evident that PW1 prosecutrix in her examination in chief admitted that appellant Gulab Yadav is known to her for about last 1 year. Full stop. She has admitted that no incident took place with her. Full stop. She has further stated that actually her date of birth is of the year 2003, but since her height was less and she was not being given admission in the school, therefore her date of birth was mentioned as 12-10-2005. Full stop. She further states that that she was admitted in school when she had completed 8-9 years of age. Full stop. She comes from a tribal community. Next, in cross-examination, she has admitted that she has denied that the date of birth as mentioned by her to be 12-10-2003 is mentioned by her on estimation. Full stop. She has admitted that she did not made any attempt to get it corrected. Next paragraph. Prosecution has not produced her 10th and 12th class mark sheet, though she has admitted that she has studied both in 10th and 11th class. Next paragraph. PW4 school teacher has proved Exhibit P17C, in which date of birth of the prosecutrix is mentioned as 12-10-2005 and it is shown that she had taken admission on 16-6-2011. Full stop. However, school teacher PW4 admits that in rural setup, date of birth of students is recorded as per the height and physical features of a student. Full stop. He admitted that it cannot be said as to on whose instance entry in Exhibit P17 was made. Full stop. He further admits that he had recorded the date of birth on the basis of the details furnished by her parents. Full stop. He further states that he cannot say as to who had recorded the date of birth of the prosecutrix in the school records. Next paragraph. PW2, mother of the prosecutrix, has categorically admitted in her cross-examination that her marriage was performed in Baisakh of 2002. Full stop. She has 3 children. Full stop. Prosecutrix was born on 5th day of 4th month of 2003. Full stop. She has further stated that father of the prosecutrix had taken her birth certificate to Anganwadi for recording of her name in Anganwadi. Full stop. Next paragraph. Father of the prosecutrix PW3 has though admitted that he had recorded date of birth of the prosecutrix in the school and Anganwadi, but admittedly did not produce any birth certificate on record, nor any record from the concerned Anganwadi to prove that he had recorded date of birth of the prosecutrix in the Anganwadi, showing her to be born in 2005. Full stop. Thus, prosecution has failed to prove that prosecutrix was minor, especially in terms of the admission of the prosecutrix and her mother PW2, full stop. There is evidence of PW4 school teacher supporting the case of the appellant that date of birth of the prosecutrix was recorded on the basis of her physical features rather than on the basis of any documentary evidence. Full stop. Thus, when this aspect is taken into consideration, then in the light of the judgment of Honorable Supreme Court in Biradmal Sanghvi versus Anand Purohit, AIR 1988 SC 1796, prosecution has failed to prove the date of birth of the prosecutrix in terms of the requirements of Section 35 of the Evidence Act, full stop. Thus, when Supreme Court has noted that to render us has held that to within inverted commas to render a document admissible under Section 35, three conditions must be satisfied, firstly, entry that is relied on must be one in a public or other official book, register or record, secondly, it must be an entry stating a fact in issue or relevant fact, and thirdly, it must be made by a public servant in discharge of his official duty, or any other person in performance of a duty especially enjoined by law, full stop. An entry relating to date of birth made in the school register is relevant and admissible under Section 35 of the Act, but the entry regarding to the age of a person in a school register is of not much evidentiary value to prove the age of the person in the absence of the material on which the age was recorded. Full stop, inverted commas close. Thus, it is evident that when PW3 admits that a birth certificate was prepared for the prosecutrix, and on that basis he had recorded date of birth of the prosecutrix in the Anganwadi as well as in the school, then it was incumbent upon the prosecution to have produced said birth certificate on the basis of date of birth was recorded. Full stop. In absence of production of such certificate, it cannot be said that entries made in the school entry register are unrebuttable. Full stop. Thus, next paragraph. Thus, prosecution having failed to prove the age of the prosecutrix to be minor at the time of the incident, and then prosecutrix saying two things, namely, she was adult at the time of the incident, and secondly, Gulab Singh did not do anything with her to violate her privacy, and there being no DNA report है क्या कोई?
हाँ सर पॉजिटिव है.
छोड़ दो. Therefore, in view of the fact that prosecutrix was a consenting adult, mere positive DNA report as contained in exhibit
P53.
huh?
P53.
P53
Ma'am.
is not a sufficient circumstance to uphold the conviction. Conviction, full stop. A relationship between two consenting adults cannot be a subject matter of dispute to uphold conviction. Accordingly, conviction of the appellant from charge under Itna is set aside. Appeal is allowed. Case property be disposed of in terms of the directions of the trial court. Record be sent back. If appellant is not required in any other case, he be released forthwith.
40 हो गया.
40 हो गया, 40.